In Uganda's tax system, time is not just a procedural step. It is a legal boundary that determines whether a dispute may be heard or must be dismissed. For Ryeru Agencies Ltd, a distributor in western Uganda, this boundary became the decisive point in a long tax disagreement. This is the story of a tax assessment, an objection, a delayed discovery, and a moment when the law finally closed the door. On the 17th of August 2022, the Uganda Revenue Authority issued Ryeru Agencies a tax assessment of 113,135,944 shillings. The company's accountant lodged an objection, as allowed under Section 26 of the Tax Procedures Code Act. This section gives a taxpayer 45 days to object to a tax decision. URA issued an objection decision on the 27th of February 2023, but this decision never reached senior management. For nearly 2 years, the company continued operating normally, unaware that the objection had already been determined. In March 2025, the managing director discovered, by chance, that an objection decision had been issued nearly 2 years earlier. He immediately contacted a tax consultant. The company then entered alternative dispute resolution, a mediation process recognized under tax administration practice. Meetings were held with URA between April and June. The final alternative dispute resolution session took place on the 12th of June, but no agreement was reached. With no settlement achieved, Ryeru Agencies filed an application before the Tax Appeals Tribunal on the 30th of June 2025, asking for more time to challenge the objection decision. But by this time, more than 2 years had passed. At this stage, the governing law was the Tax Appeals Tribunals Act, which regulates all applications for review before the tribunal. Under Section 16, subsection 1c of the Tax Appeals Tribunals Act, a taxpayer must lodge an application for review within 30 days after receiving an objection decision. This section also gives the tribunal power to extend the time for filing the application. However, the same act contains a strict limit. Section 16, subsection 7 of the Tax Appeals Tribunals Act states verbatim, "An application for review of a taxation decision shall be made within 6 months after the date of the taxation decision." This 6-month period is absolute. After it expires, the tribunal no longer has the jurisdiction to extend time. Ryeru Agencies filed their application 2 years and 4 months after the objection decision, far beyond the 6-month legal boundary. Ryeru Agencies explained that the delay was caused by unavoidable personal circumstances. The managing director had spent extensive time caring for his father, who later passed away. They also explained that the accountant responsible for tax matters did not inform management that an objection decision had been issued. They argued that once the decision was discovered in 2025, they acted quickly. They sought professional advice, entered alternative dispute resolution, and attempted to resolve the matter amicably. They also paid the mandatory 30% deposit required under Section 15(1) of the Tax Appeals Tribunals Act, Cap 345, which must be paid before a dispute can proceed. They believe this demonstrated good faith and sufficient cause. URA opposed the application based on the law. They argued that Section 16, subsection 7 of the Tax Appeals Tribunals Act removes the tribunal's power to extend time once the 6-month period has passed. In their view, the tribunal simply had no legal authority to entertain the application. URA also noted that Ryeru Agencies is a corporate entity. The personal hardship of one officer, however genuine, could not justify a delay of more than 2 years. URA further emphasized that alternative dispute resolution does not pause, suspend, or reset statutory deadlines. The tribunal considered both sides carefully. It acknowledged the managing director's personal hardship, but emphasized that companies are expected to maintain internal controls that ensure continuity in tax compliance. The tribunal focused on the law. The application had been filed 2 years and 4 months after the objection decision was issued. Yet the Tax Appeals Tribunals Act requires such an application to be filed within 6 months, stated clearly under Section 16, subsection 7. Because this provision is mandatory, the tribunal concluded that it no longer had jurisdiction to extend time. Even if the company had strong grounds to challenge the assessment, the law prevented the tribunal from reopening the matter. On the 5th of November 2025, the Tax Appeals Tribunal dismissed the application for extension of time. The dismissal did not mean the company's concerns were unfounded. It meant the law did not permit the tribunal to hear a dispute filed so far outside the statutory limit. In this case, time, not evidence, decided the outcome. This case highlights important lessons for all businesses. Track tax decisions carefully. Ensure strong internal communication. Know the timelines under the Tax Procedures Code Act and the Tax Appeals Tribunals Act. And remember that alternative dispute resolution does not stop legal deadlines. In tax matters, even a strong argument cannot survive an excessive delay. Respecting time limits is what keeps the door open for your case to be heard. What do you think about this ruling? Should the law remain strict on timelines, or should there be more flexibility for genuine hardship? Share your thoughts and suggestions, and let's discuss in the comments.